So hello everyone, for those who haven't met me yet, I am Maria, I'm a doctoral student at the University of Turku. And today I would like to talk about a legal perspective on data protection and privacy concerns in loyalty mobile apps. So, as we all know, loyalty mobile apps involve location tracking, behavioral advertising and other loyalty schemes. And all these processing activities have been classified by the Article 29's Working Party as regular and systematic monitoring of consumers' behavior. Well, according to the GDPR Recital 24, what means monitoring? Monitoring is that is the process of tracking consumer and the use of his personal data for analytics and predicting the future behavior, his personal preferences, behaviors, and attitudes of the consumer. So there's there are some privacy risks for the consumer. The first step in this monitoring of the consumer behavior, we have the collection of the user information. And let's keep in mind that when we are talking about loyalty mobile apps, the monitoring of the consumer is two-sided. We have the monitoring through the mobile platforms and the tracking of the consumer through the loyalty schemes. So, as you can see here, I divided these two sides of the monitoring. And when we are talking about the categories of data collected, we have this, when you're installing your mobile app, the service provider is going to ask access to your personal information stored in your phone. And also we have the collection of personal data through loyalty schemes. So they can collect your visit frequency, spending habits, and other information. So this is how it looks through the loyalty schemes, and this is how it looks on the mobile platforms. So when you want to download a mobile app, a loyalty mobile app, they're asking access to this type of information. And which is more important is that maybe some of this information are not classified as personal information, but they are part of your private life. And it's quite scary. So, moving on, when we are talking about monitoring the consumer behaviors, we are talking about the site-based process. We start with the collection of the personal data, identification of the consumer, with or without the knowledge of the consumer. Then we have the profiling, when the dossier of the consumers are compiled. And those profiles are reflecting the economic value of the consumer on the information market. And then we have the classifying of the consumer in more general categories and discovering specific patterns. And then we have the assessment when the companies are checking whether the response from the consumers was positive. And then again, we have collection of, so it's a cyclic process, which is continuous. But of course, there are excuses. The personal data of the consumers is quite crucial for both app providers and third parties because they enable functionality for customized content, for targeted advertising, and of course, for analyzed usage. And these are some of the privacy risks perceived by the consumer. So we have lack of meaningful control, we have the opacity because the consumer might not know what's happening with his data or what methods of processing of personal data are used. And we have decontextualization, the collection of data in one context and applied it in another context. We have insights about sensitive information, for example, from the information regarding the spendings in one shop, you could find about the health of the consumers or other more sensitive information. We have data maximization when more and more data is collected, and also affected free choice. Yeah, there is a personalized content, but still the offers are quite limited. So is it a real free choice of the consumer, or it's more than that? And the most important is that we are aiming towards a surveillance society where the consumer is surveilled and data veiled everywhere, online and offline. And now turning to more legal information. In case of loyalty card apps, the applicable legal ground for data processing is consent. And consent, it plays a double role in the sense that we have consent for the consent of the consumer for the service provider to place information on the device and access the information from the device, and also consent for the processing of the personal data itself. I'm going to leave it only to the first point because Niklas is going to talk about the second point under GDPR. So this is the article that that talks about the consumer consent requirement in case of placing information and accessing information on the device of the user. So the storing of information and gaining access to information stored on the mobile, it's only allowed on the condition that the consumer gives his consent. And these are some interpretations from the Working Party, Article 29, regarding this article. So this article applies not only to personal data, we are talking about any data that you have stored in your mobile phone. Also, it applies to every entity. It doesn't matter if it's a data controller, a data processor, or a public or private company. And it also applies to all the services provided for a consumer who is in the European economic area. So, regardless of whether the service provider is located, this article applies. Well, because this article was not achieving its potential in strengthening the control of the consumer, we have a new article, a new proposal, not the GDPR, a new proposal for regulation on privacy and electronic communications, where the consent requirement was changed, it was modified. So, considering the new technological developments, the European Commission this year, in January, they adopted this proposal, and they changed quite a bit the wording of the consent requirement. So, if before, as you can see, this storing of information and accessing information from the device was allowed only if the consent was given, here, the same process of storing and getting access to the information, it's prohibited. Unless, of course, and we have here, the end user has given his or her consent. So it's quite a change in the wording of the articles. Let's see if it's going to be effective or not. And, well, there are other exceptions that were proposed to be added there, namely the anonymization of data collections and other processing that doesn't have any negative impact on the privacy of the consumers. And here it's a final thought, you can consider it. So it's really important that to understand that if we don't have a meaningful consent from the consumer side, then we have an illusion of consumer sovereignty. So it's really important to address these issues, the lack of awareness of the types of information collected, the lack of transparency of the types of processing, and the purposes for which the data is collected. So if we are not addressing these issues, then we are not going to have a meaningful consent, and then we are going to talk about issues of trust and ultimately an illusion of consumer sovereignty. So that was fun.